Well, changing gears now, the deaths of two high-profile South Africans, hip-hop artist HP and more recently and of course former Springbok captain Joost Van Der Westhuizen have thrust the question of wills and divorce firmly into the spotlight. HP's estranged wife Lerato Sengadi was able to successfully challenge his biological family in order to gain access and possession of their marital home when they disavowed her marriage to the musician. And yesterday, Amor Vittone lost her bid to claim a share of her late ex-husband Joost Van Der Westhuizen's estate. Now, how might a will have prevented that confusion? We are joined now by senior associate at Poswa Incorporated, and that is, of course, Lungiswa Momoti. Lungiswa, very good evening to you, and thank you so much for talking to us. I mean, these are very specific cases, but I think there's a lot to be gleaned from them by South Africans. Let's start with the HP setup, because that's the more recent one. This was a couple that was married under customary law, and there were debates about whether or not the family recognized that marriage. Where does a will come in when the marriage is not perhaps formally registered, at a court, but rather a customary one? How might a will have assisted in that situation?
Well, good evening, Bungani. Let me start by saying a will is very, very important. And what a will is, it's a document whereby you state your wishes. That is, when you depart, then the people who are left behind will be able to wind up your estate. That is in accordance to your wishes that are stated in your will.
The difficulty is, of course, these things aren't as simple as they may seem, because, for example, in the Joost Van Der Westhuizen matter, there was a will, but we know, of course, he passed away due to an autoimmune disease and wasn't able to put a signature on his final document that his lawyers submitted. It's gone all the way to the High Court, and the court ruled in favor of his family and the kids specifically. Again, a will would have helped in that situation, would it not?
Well, Bongani, to be honest, that's why it is crucial that we ensure that we do have valid wills. When you speak of a valid will, it's a will that has been signed by the testator. There must be witnesses to witness the will, like the requirement is like each and every page has to be witnessed. So it's very, very important that we mainly attend to these things while we are still living. But the problem is there is always fear when it comes to talk about mortality. So that's where the problem is. In this recent case, I won't really blame the judge, because the will did not comply to the requirements of a valid will, because it was unsigned by the testator, which is crucial.
Let's just talk about the responsibilities of not only making sure one has a will in place, but also how important is it to communicate to, shall we call them, affected parties, what it is that you've written in your final testament?
It is important, Bongani, because I always advise clients, that is when they come into our offices, to create wills. I always say to them, you have to advise one of the family members. That is whereby you'll be like saying that my will is at Poswa Incorporated, or I have a will in my case, whichever. So
it's not just about your possessions, as it were. It is also about a number of other issues. I mean, let's maybe take a step back and ask, why is it important to have a will?
It is important to have a will because a will mainly deals with all your assets.
Yeah.
That is anything that you've accumulated during your lifetime. Your investment, your movables, your immovables. Then you have to mainly state your wishes as to such and such property should be inherited by so and so. So it's all about estate planning. A will is just about estate planning. We wouldn't be having the problems that we're having, like looking at the case of HP. Because for HP, if he had a valid will, maybe, nobody knows, he would have included Lerato. Nobody knows.
But even sometimes when there are valid wills that have been signed, they are still open to contestation.
They are, but a will mainly be contested. Okay, let me give you a scenario. Let's say there is a valid will. When it comes to a will, it's your wishes. If you have 3 kids, then you decide that you want to disinherit one, or you disinherit a child that you have that is outside the marriage. Then in those instances, you'll find out that the will be contested, or the ex-wife or anyone. So that's where they mainly end up contesting the will. But the fact that there is a valid will, then the people who are mentioned in the will definitely inherit. The matter will definitely go to court. The judge will have to decide on it. But the fact that the will is a valid will, the judge will mainly consider the validity of the will.
Are there people who have automatic rights to an estate in the absence of a will?
Yes, I would say so. What happens is that an estate is either it's testate or it's interstate. When you say it's testate, that means there is a valid will. Then when it's interstate, there is no valid will. Then in that case, if there is no will, then the act will definitely kick in.
And what does the act say?
The act, firstly, it's the preference. It gives preference to the spouse, then to the descendants. Then if there is no spouse, there's no descendants, then it goes up to the parents. It moves up, that is the tree now. Then if there are no parents, then it goes down to the siblings. So you just have to follow the act. It also caters for adopted children, that is legally adopted children. So if there is no valid will, then the act kicks in.
One of the discussions that, and we started this conversation by going there around customary law and the recognition of those arrangements. Where do the rights of the family, the biological family of the deceased come in and end, and where do the rights of the spouse come in and end when there is no will?
When there is no will, as I have already indicated, the first person that is considered according to the Act, that is Section 1, it's the spouse. Regardless of whether the marriage is customary or a more formalized one? Like for formalized one, it's the spouse. Then if it's customary, let's say the deceased had like 5 wives, all those wives will be considered, but they'll be treated as if they are the children. All right, we'll have to leave our conversation there. The important point you want to make, of course, is that everyone check your will, update your will, yes. Make sure it is your final testament. Yes, all the time you just have to check your will. The moment there are new developments, there are new bonds, you've accumulated more assets, you just have to change your will. You must always be in contact with the person who's in charge of your will, that is your attorneys, your trust company, whichever. And it's very, very important that you rather go for trust companies, for attorneys, that is the people who know quite well, will be able to advise you about any changes when it comes to law, any amendments. All right, we'll have to leave it there. Lungiswa Momoti, thank you very much for coming in this evening. It's important, make sure you have a will, make sure you update it and communicate your wishes. Stay with us, we've got more.